I want to read you something. A man emailed me this a few weeks ago. He got it from a law firm. I've changed the names, but the words are close to the real thing. And here's what it says. It states this: Dear Mr. Hammond, this firm represents the claimant in the above matter. Our investigation has identified the following assets held in your name: a single-family residence on Maple Street, a duplex on 3rd Avenue, a commercial building held in your business, and your ownership interest in Harmon Properties, LLC, plus 3 properties in Phoenix, Arizona. We are prepared to pursue collection against each of these. Unless we receive payment of the demand below within 14 days, we will file suit and satisfy any judgment from every asset identified above. Okay, and then there's a number at the bottom, and that is a big number they've listed down here at the bottom of this letter. Now listen, Dave called me the day this landed, and the first thing out of his mouth wasn't a legal question. It was this: hey, how did they find all of it? And right behind that, he said, can you make it go away? You see, that's what this whole video is about today. I'm going to talk to you about asset protection because it only exists for one reason, and that reason, you can do something about it, but only before the letter shows up. So let me show you what I mean. Okay, so most people read the letter wrong. Dave did. He assumed that a lawyer had some type of inside information on him, like somebody was telling him about his assets. There's a snitch in his family. Okay, that's almost what's never happening. Here's what actually happened. Before that firm drafted this letter, a single word of it, somebody ran an asset search on Dave. Now, what is an asset search? It's just where somebody pulls together a report that shows everything you own publicly that's tied to your name: property records, business filings with the Secretary of State, vehicle registrations, past addresses. There are firms that do nothing else. An attorney can order one for a few $100s. You see, that's the part that no one tells you. They don't need to sue you to run it. There's no court order. There's no notice. It's not like running your credit report where you have to get permission. You don't even know this is happening. And by the time you receive that letter, okay, your entire balance sheet is sitting on a PDF on some paralegal's desk. And understand how the complete picture this is, because people underestimate it. You see, the county recorder, it's public. Every deed with your name on it is searchable by name. Okay, so that means your personal residence, rental properties you own, all searchable. The Secretary of State is public. Every LLC where you're listed as a member or manager or organizer, okay, recorded mortgages and deeds of trust are public. So they don't just see that you own the duplex. They can estimate now how much equity is sitting inside of that duplex, right? Because those are two different things. You could have a property, but if it's completely encumbered, well, then it's not an asset to you. But if there's equity there, that is now an asset, and that's what the other side is looking for. Vehicle records, old addresses, any prior lawsuits, and they've sketched your whole net worth without ever picking up the phone. So why would a lawyer spend money searching you before they filed anything? Because of how these cases get paid. A lot of plaintiffs' attorneys work, as you know, maybe you don't, on contingency. So that means this: the lawyer only gets paid if they collect. Okay, the time that they put forth up front, that time and cost, what they're doing is they're taking a percentage on the back end of whatever they recover. So before they take their case, they have to answer this one question: if we win, is there anything actually to collect against? So the asset search, that's how they answer it, all right? I worked for a firm like this when I was in law school. And if the search came back and your name is tied to 6 properties and 3 LLCs, I'll tell you what, congratulations, because you're now a very attractive defendant to these firms. You're collectible, and that's what they're looking for. That was my job when I worked for this firm. Because here's how a contingency lawyer actually scores you. 3 questions, right? Is there enough there to make it be worth it? Is it easy to get to, or is it buried? Because that's always going to factor in. Hey, maybe it's there, but if it's going to take us too much time and effort to get to it, then it's not worth it. And then how certain is the collection? So a name attached to 6 properties, guess what? That's going to score high on all 3 of these. Worth it, easy, certain, that's a green light. And that letter you got, it isn't really a legal document, it's shaking the tree. Okay, so what they're doing is they're going to rattle the branch, list everything they found, set the demand high on purpose, and wait to see what falls out. They want you scared enough to write a check before anyone walks into a courtroom. And it almost worked on Dave. He was ready to settle the day he called me just to make the fear stop. And this is something I tell people all the time in this situation.
If you have protection in place and someone's coming after you, what you do is you take this letter right here and you do this to it. And you just toss it. And you call their bluff and you make them file. And then you'll know if they're serious or not. You see, what that attorney did is by design, okay? It's a short clock, the scary number. It's built to make you act before you think, before you ever talk to someone like me. And there's a lot of people who get one of those letters and they try to settle it out and they reach out to the other side. And I always tell people, don't do that, right? The letter works precisely because the search worked first. And that's the whole thing. But if you step back and look why it worked because the search found something. The search, the letter, the demand, the whole machine runs on one assumption, that when they look you up, your name is on everything. So the real question was never, how do I answer the letter? I mean, it's what does the search find when they look me up? So what do we want to do then? Okay, so let me just basically go to the whiteboard. I'm going to draw out two versions here of the same investor, right? The same person with 6 properties, the same net worth. The only difference is going to be how it's held. So you've got this individual right here. Okay, this is like our problem with Dave. He has all these properties, okay, 6 of them. Okay, they're all tied to him individually, right? They're all in his name. Okay, now let's assume that he didn't have them all in his name. Instead, he had an LLC set up over 2 of them, just like this. Well, if he's listed on that LLC as the member or manager, then these LLCs would also be tied to him. So you see, it's one thing to have property in your name, and people think, well, if I put it into a limited liability company like this investor did, well, then that's going to protect it. No, it won't. If your name's on the LLC, it's going to tie it right back to you. Because all they have to do is go to the Secretary of State's website and they do a search for your name and they find that you have this LLC. So once they find out that you have the LLC, then what they'll do is they'll search the LLC and they'll see whether or not it owns real estate. Okay, and that's how you're found. Everything's pointing back to you. Okay, see, Dave, he actually had LLC set up. And he thought he had protection, but an LLC with your name on it's a public filing. It's not anonymity. It's a forwarding address, if you want to think about it. The search comes about, and they say, hey, this guy has assets. Now, let's look at this other investor. So we have another investor over here. Okay, I'll call this an Anderson client, right? And generally what they're going to do, the way we're going to structure them, is we're going to take properties, but we're not going to tie them back to you. We're going to set assets up so people cannot see that you own them. So I'm just going to do 3 here for saving some space. So with these, we're going to use land trusts like this. Okay, so these will be land trusts that will hold title to the property. Now, when you set up a land trust, you always want to use this. This is critical. You want to use what's called a nominee trustee. Okay, so we're going to use a nominee trustee on all of these land trusts. Now, what is a nominee trustee? So a nominee trustee is someone other than you. It could be a Wyoming LLC that your name's not attached to. It could be a third party. I've served on tens of thousands of trusts where my name's listed as the trustee. So on title, if somebody looks for this individual, let's call this Ken, they'll never see these properties tied to them because a land trust is a private document. And they'll never see Ken tied to the property because now the property is tied in the name of a trust under a nominee trustee's name. So on title, let's say this one right here, it might say Clint Coons, trustee of the Green Turtle Trust. Just like this. Okay, now, Ken's nowhere to be found on this. Because we're not broadcasting now that Ken's tied to this asset. It's completely hidden. Now, then we go about protecting these assets. We'll create separate LLCs down here. So just like Dave's structure, but the trusts now stand as that blocker. Now, when you create these LLCs right here, this is the key component you need that Dave did not have. You need a Wyoming limited liability company. This is a Wyoming LLC. I refer to this many times as a blocker entity. So this is a perfect privacy stack. If you were to run that same search, this law firm were to run that same search on Ken, okay, nothing's going to come back pointing to him. That's the point of setting up the structure. Every line back to Ken now ends
And nothing, zero, because Wyoming doesn't share any information on its members or managers of its LLC because it doesn't collect the information. Whereas if these LLCs that Ken set up here were all in Texas, Texas collects that info. And if Ken was listed as a member or manager there rather than his Wyoming LLC, you would see a line directly to Ken. But we eliminate these connections by using blocker entities, and Wyoming is a perfect blocking entity. And again, this works both ways, right? So if you look at the asset, you never see Ken. If you look at Ken, you never see his assets or his business entities. Okay, this is important, okay? Okay, I've had clients just like Ken that I've structured that have been involved in lawsuits. And those cases turned out the way we wanted them to, where the attorney went away, took some insurance money, and left him alone because they assumed Ken had no assets. This is what we're going for when we're putting these types of plans together. We don't want to be in that situation where we're an open book and we're an easy target. Okay, so let's go back to Dave. Okay, you see, Dave asked me the question everybody asks. Can we just move everything now? Put it all in a trust, set up that Wyoming holding company, that blocker entity, and get my name off of all my assets before they file? Because Clint, they just sent me the letter. They haven't filed a lawsuit against me. And that's where I had to tell them no. And I want to be really clear about why. Because this is the most important 90 seconds of this video. The moment a claim exists against you, the rules change. All right? There's no doctrine, okay? I mean, there is a doctrine, excuse me. Most states call it a fraudulent transfer or voidable transaction. It's really important you understand this because in plain English, here's what it means. If you move assets to put them out of a creditor's reach after a claim has already arisen or you're under a reasonable degree of certainty that you're about to be sued, a court can unwind it. That is, reverse all those transfers and drag the assets right back to you and put them in your name. Because now you're looking like somebody who's trying to hide their assets from a creditor. You didn't do it to protect anything, okay, or to do it for a business purpose. You did it to hide assets. Okay, that is a problem. So what you've done now is you've handed the other side basically another weapon against you. And notice the line here, because it matters. Setting this up when no one's coming after you is legitimate planning, right? Business planning. It's what every sophisticated investor does. Doing the same moves after a claim shows up specifically to dodge that creditor is what crosses into that voidable transfer. Same paperwork, but completely different legal world. The only thing that changes here is timing. Then Dave asked a question I really couldn't touch. He said, if we could just date the document earlier, right? And I've had this come up before. People will call in and say, hey, just backdate it, the trust, so it looked like it had been set up last year. Okay, the answer to that is always going to be no. Every time, from anybody, no. Backdating a document is another way of showing you try to defraud a creditor. It's not a strategy. It's something that the judge will hammer you on court when it turns out that you backdated something. And then it turns into a civil money problem. Okay, it turns a civil money problem into a potential criminal problem if you get under oath and you say, yes, I signed this a year ago, and they show that you lied under oath. And any advisor that you meet, say you're searching on the internet for somebody for asset protection, you're not using our firm, and they say, yes, you can do this. Listen, they're not protecting you. What they're doing is they're trying to sell you. The fact that Dave even told me how scared he was, but fear is not a reason to commit a fraudulent transfer like this. So listen, here's the hard truth. Dave, I'll give it to you. Everything we talked about, the trust, the entities, the anonymity, it's enormously powerful, but it's a fence you build before the storm, not after. Build it while everything's fine, you're not under a reasonable degree of certainty of being sued, and your case will turn out completely different. Best of all scenario, you'll never even know that there's a law firm out there, like in Dave's situation, that is considering bringing a case against you. Because when you build the fence early and protect your assets, what happens is when they run that search, it comes back with a big fat zero, okay? And they think you're not worth spending their time on, and they're gonna go find another Dave. Okay, and that's what you want to do. You want to have this in place long before anyone runs that search. Three things working together, right? I'll tell you what each one does, but I'm going to stop short of the build because how it's assembled for you depends on your state, your properties, your loans. That's a conversation, not a YouTube video. I tell everyone all the time, it's not a one-size-fits-all approach, okay? So one, here are the three steps. One, you want to make sure title to your property is held privately, right? Your properties need to come out of your personal name and put them typically into land trusts with a nominee trustee so the public deed doesn't lead, like I said earlier, a directory on everything you own. This is the layer that makes the asset search come back and it says, hey, there's nothing there. When the recorder's index doesn't return your name, the very first step of the search fails and you've cut the investigation off at its knees. Okay, so number two, liability separation. Okay, the day-to-day exposure. Tenants, leases, contractors sit inside an operating entity structured so the public filing doesn't just hand your name to anyone who looks. One property's problem stays at that property. It doesn't reach across the table and grab the other 5 properties. Okay, and the third thing is that the ownership sealed or blocker entity sits on top. That's where you want to use a holding company. A Wyoming LLC is the common one. It's this blocker entity, and there's 2 reasons. It keeps your name out of the public record, and it carries something else that we didn't even talk about earlier that I guarantee you Dave's going to wish he had, and that is called charging order protections. And so what that means is that even if a creditor gets a judgment against you personally, if you have a LLC set up in Wyoming or Delaware, then you have this extra protection. That means that a creditor cannot take your LLC from you. And this is one of the biggest mistakes I see with people who set up business entities and they think that they have asset protection with their LLCs. They're not thinking it from the standpoint that what happens if you get sued? Can a creditor take your LLC? I mean, yeah, I get it. They sue the LLC. I should be protected from what happens at the LLC level. But if they come after me personally, maybe they can take my LLCs. And in a lot of states, that can happen. So one more thing. Because I don't want to hear you to hear this as a silver bullet. The structure doesn't replace your insurance. It works alongside of it because, again, people say, I'll just drop insurance if I set up the structure. No, you still need that. In fact, if you don't have insurance, then what will happen is they'll blow right through your protection. So these are all layers, right, that come together. So if you want to know how to build out a layer for yourself to create the right entity stack, to create a system around your assets and your business that gives you privacy and asset protection, and to put something in place that'll make Dave's problems, okay, if it was your situation, completely disappear as if the claim never existed, then what you can do is you can reach out to us and I can offer you a free strategy session. All you got to do is go into the show notes. There's a link there. Click on that. You can set up the free strategy session and we'll go through your assets, design out a system for you to make sure that you're accomplishing everything that I talked about in this video. So again, if you were Dave, you won't be calling me up and saying, hey, what can you do to help me now? Because you know what the answer is always going to be, I can't. Hey guys, if you liked the video, be sure to hit the like button. It helps me out on YouTube, gets this information out there to more people. And if you're not yet a subscriber and you want to get more content like this when I release it every week, be sure to hit the subscribe button. All the best with your investing.